Okay, so another part of commercial law, the intellectual property law. So it governs patents, trademarks, and copyright. Let's start with patents. So what are patentable inventions? These are any technical solution of a problem in any field of human activity which is new, involves an inventive step, and industrially applicable shall be patentable. It may relate to a product, a process, or an improvement of any of the foregoing. So the standards or requirements for registrability, it must be novel, it must involve an inventive step. So novel, it must involve an inventive step, and it must be industrially applicable. Next, what is novelty? So an invention shall not be considered new if it forms part of a prior art. A prior art shall consist of everything which has been made available to the public anywhere in the world before the filing date or the priority date of the application claiming the invention. So generally, when a work has already been made available to the public, it shall not be patentable for absence of novelty. Exception: the disclosure of the information contained in the application during the 12 months preceding the filing date or the priority date of the application shall not prejudice the applicant on the ground of novelty if such disclosure was made by the inventor himself, the patent office that should not have disclosed the information, and the information was found in another application by the same inventor or a third party who obtained the information directly or indirectly from the inventor. What is an inventive step? So, an invention involves any an inventive ano an invention involves an inventive step if having regard to prior art is not obvious to the person skilled in the art at the time of the filing date or priority date of the application claiming the invention. The test of obviousness is if any person possessing ordinary skill in that art was able to draw the inferences and he constructs that the supposed inventor drew from any prior art, then the latter did not really invent it. Next, it must be industrially applicable. An invention that can be produced and used in any industry shall be industrially applicable. This means that an invention is not merely theoretical, but it has a practical purpose. If the invention is a product, it should be able to produce a product. And if it is a process, it should be able to lay out a process. So what are non-patentable inventions? The following shall be excluded from patent protection. 1. Discoveries, scientific theories, mathematical methods. 2. Schemes, rules and methods of performing mental acts, playing games, or doing business, and programs for computers because programs for computers are governed by copyright. Methods for treatment of human or animal body by surgery or by therapy and diagnostic methods practiced on human or animal body. Plant varieties and animal breeds are essentially biological processes for the production of plants or animals. This provision shall not apply to microorganisms, and non-biological and microbiological processes shall not. And aesthetic creations and anything which is contrary to the public order or morality. Ownership of a patent. So generally, the right to a patent belongs to the inventor himself, his heirs or assigns, or when there are two or more persons having jointly made an invention, the right to a patent shall belong to them jointly as co-owners. If two or more persons have made the invention separately, and independently of each other, the right to the patent shall belong to the person who filed an application for such invention. And when two or more applications are filed for the same invention, the applicant who has the earliest filing date or the earliest priority date shall own the patent. Exception. Inventions created pursuant to employment or a commissioned work. So the person who commissions the work shall own the patent. The employer has the right to the patent if the invention is the result of the performance of employees' regularly assigned duties. So what is the first to file rule? So if two or more persons have made the invention separately and independently of each other, the right to the patent shall belong to the person who filed an application for such invention. When it is filed for the same, when two or more applications are filed for the same invention, the applicant who has the earliest filing date or the earliest priority date. The filing date of the patent application shall be the date of receipt by the office of the IPOFIL of at least the following elements: an express or implicit indication that the Philippine patent is sought, information identifying the applicant, and the description of the invention, and one or more claims in Filipino or English. Right of priority. An application for patent filed by any person who has previously applied for the same invention in another country which by treaty, convention, or law affords similar privileges to Filipino citizens shall be considered as filed as of the date of filing to the foreign application, provided that the local application expressly claims priority and it is filed within 12 months from the date of the earliest foreign application was filed, and a certified copy of the foreign application together with an English translation is filed within 6 months from the date of filing in the Philippines. The rights of a patent owner. So where the subject matter of the patent is a product, the patentee shall have the exclusive right to restrain, prohibit, and prevent any unauthorized person or entity from making, using, offering for sale, selling, or importing that product. Where the subject matter of the patent is a process, the patentee shall have the exclusive right to restrain, prevent, or prohibit any unauthorized person or entity from using the process, from manufacturing, dealing in, using, selling, offering for sale, or importing any product obtained directly or indirectly from such process. When the patent owner shall also have the right to assign, transfer by succession the patent, and to conclude licensing contracts for the same. The limitations of the patent rights. The owner of the patent has no right to prevent third parties from performing, without his authorization, the acts referred to in Section 71 in the following circumstances: owner's consent, parallel importation, non-commercial, experimental use, valor exception, individual preparation of medicine, and usage in vessels. Prior use. Any prior use who, in good faith, was using the invention or has undertaken serious preparations to use the invention in his enterprise or business before the filing date or priority date of the application on which a patent is granted shall have the right to continue the use thereof as envisaged in such preparations within the territory where the patent produces its effect. The use by government. A government agency or third person authorized by the government may exploit the invention even without agreement of the patent owner where the public interest, in particular, national security, nutrition, health, or development of other sectors as determined by appropriate agency of the government so requires. A judicial or administrative body has determined that the manner of exploitation by the owner of the patent or his licensee is anti-competitive. In case of drugs and medicines, there is national emergency or any other circumstance of extreme urgency requiring the use of the invention. In the case of drugs and medicines, there is a public non-commercial use of the patent by the patentee without satisfactory reason. And in case of drugs and medicines, the demand for the patented article in the Philippines is not being met to an adequate extent on a reasonable terms as determined by the Secretary of the Department of Health. Okay. So what is patent infringement? It is the making, using, offering for sale, selling, importing a patented product or product obtained directly or indirectly from a patented process, and use of the patented process without the authorization of the patentee constitute patent infringement. Anyone who actively induces the infringement of a patent or provides the infringer with a component of a patented product or a product produced because of a patented process knowing it to be especially adopted for infringing the patented invention and not suitable for substantial non-infringing use shall be liable as a contributory infringer and shall be jointly and severally liable with the infringer. Cancellation of a patent. So he who may file a petition for cancellation. Any interested person may, upon payment of the required fee, petition to cancel the patent on or any claim thereof or parts of the claim on the grounds that what is claimed as an invention is not new or patentable, that the patent does not disclose the invention in a manner sufficiently clear and complete for it to be carried out by any person skilled in the art, and that the patent is contrary to public order or morality. So, trademarks. So, marks versus collective marks and trade names. So, marks, these are visible signs capable of distinguishing the goods, such as trademark, or services, such as service mark, of an enterprise, and shall include a stamp mark or contain a stamped or marked container of goods. Collective marks, on the other hand, is any visible sign designated as such in the application for registration and capable of distinguishing the origin or any other common characteristic, including the quality of goods or services of different enterprises which use the sign under the control of the registered owner of the collective mark. And trade names means that the name or designation and identifying or distinguishing an enterprise. Okay. So the spectrum of distinctiveness. So generic marks are those which constitute the common descriptive name of an article or substance, or comprise the genus of which the particular product is a species, or are commonly used as the name or description of a kind of goods, or imply reference to every member of the genus and the exclusion of individuating characters, or refer to the basic nature of the wares or services provided rather than the more idiosyncratic characteristic of a particular product. Next is descriptive marks. So this consists descriptive marks. It consists exclusively of signs of or indicators that may serve in trade to designate the kind, quality, quantity, intended purpose, value, geographical origin, time, or production of the goods, or rendering of services or other characteristics of the goods or services. So generally, descriptive marks are not entitled to protection and are too weak to function as a trademark, except the doctrine of secondary meaning. A word or phrase originally incapable of exclusive appropriation with reference to an article on the market, because geographically or otherwise descriptive, might nevertheless have been used so long and so exclusively by one producer with reference to his article, that trade, and to that branch of the purchasing public, the word phrase has come to mean that the article was his product. Example here is Ginebra. Okay. Third, suggestive marks. So suggestive marks are marks that hint or suggest the nature or quality of the goods or service without directly describing it. They are subtly descriptive and are entitled to protection despite lack of distinctiveness. And arbitrary marks, these are common words used as marks but are unrelated to the good or service they represent. They neither describe nor suggest the characteristics of the goods or service, though they are considered highly distinctive for purposes of registration. Example is Apple products used on phones. Fanciful or coined marks. So these are invented or coined words that do not have any meaning and are made solely for the purpose of the mark. They are considered strong marks for purposes of registration and protection for being inherently distinctive. So what are not non-registrable marks? So a mark cannot be registered if it consists of immoral, deceptive, or scandalous matter, or matter which may disparage or falsely suggest connection with persons living or dead, institutions, beliefs, or national symbols, or bring them into contempt or disrepute, consists of flag or coat of arms or other insignia of the Philippines or any of its political subdivisions or of any foreign nation or any simulation thereof, consists of name, portrait, or signature identifying a particular living individual except by his written consent, or the name, signature, or portrait of a deceased president of the Philippines during the life of his widow, if any, except by written consent of the widow. Also, a non-registrable mark. A mark cannot be registered if it is identical with the registered mark belonging to a different proprietor or a mark with an earlier filing or priority date in respect of the same goods or services. Ayan. Closely related to goods or services, or if it nearly resembles such mark as to be likely to deceive or cause confusion. Another, if it is identical or confusingly similar, or constitutes a translation of the mark which is considered by the competent authority of the Philippines to be a well-known internationally and in the Philippines, whether or not it is registered here as being already the mark of a person other than the applicant for registration, and used for identical or similar goods or services, provided that in determining whether a mark is well known, account shall be taken of the knowledge of the relevant sector of the public rather than the public at large, including knowledge of the Philippines which has been obtained as a result of the promotion of the mark, is identical or confusingly similar, or constitutes a translation of the mark considered well known in accordance with the preceding paragraph, which is registered in the Philippines, with respect to goods or services which are not similar to those with respect to which the registration is applied, provided that the use of the marks in relation to those goods or services would indicate a connection between those goods or services and the owner of the registered mark, provided further that the interests of the owner of the registered mark are likely to be damaged by such use. Another, it is likely to mislead the public, particularly as to the nature, quality, characteristics, or geographic origin of the goods or services. It consists exclusively of signs that are generic for the goods or services that they seek to identify. Consists exclusively of signs or indications that have become customary or usual to designate the goods or services in everyday language or in a bona fide and established trade practice. It consists exclusively of signs or indications that may serve in trade to designate the kind, quality, quantity, intended purpose, value, geographic origin, time, or production of the goods or rendering the services or other characteristics of the goods or services. It consists of shapes that may be necessitated by technical factors or by the nature of the goods themselves or factors that affect their intrinsic value. It consists of color alone, unless defined by a given form, just like 7-Eleven. Yun pwede. Ayan. It is contrary to public order or morality. Okay. Ownership, registration, and duration of trademarks. So how are marks acquired? The rights in a mark shall be acquired through registration made validly in accordance with law. And it must be emphasized that registration of a trademark by itself is not a mode of acquiring ownership. If the applicant is not the owner of the trademark, he has no right to apply for its registration. Registration merely creates a prima facie presumption of the validity of the registration of the registrant's ownership of the trademark and of the exclusive right to the use thereof, the provisions of this law. And the duration, a certificate of registration shall remain in force for 10 years from the registration and may be renewed for a period of 10 years at its expiration upon payment of the prescribed fee and upon filing of the request. The limitation, however, except that inasmuch as the registration of a trademark could be renewed every 10 years, provided a DAO or a declaration of actual use is timely submitted, a trademark could conceivably remain registered forever. Okay. Unfair competition. So, unfair competition refers to any act contrary to honest commercial practices aimed at misrepresenting one's goods or services as those of another, misleading the consumers, and gaining an unfair advantage. It often involves imitation, passing off, or fraud. So, acts constituting unfair competition, one is passing off, representing one's goods or services as those of another by imitating labels, packaging, or trademarks. Example, using a trade name or mark similar to a well-known brand to mislead the customers. Yung mga class A. Misrepresentation, making false claims or representation about goods or services such as their origin, quality, or affiliation with another business. And other deceptive acts. Any fraudulent or dishonest act likely to cause confusion, deception, or misunderstanding among consumers about the source or identity of goods or services. So what are the essential elements of an unfair competition? To establish a case of unfair competition, the following elements must be proven. There is confusion or deception. The act must create confusion among consuming public about the origin or source of the goods or services. There must be an intent to mislead. The accused must have intended to deceive or mislead the public for commercial gain, and there is damage or injury. The act must result to damage to the aggrieved party, such as loss of sales, goodwill, or reputation. Now let's go to copyright. Copyright is confined to literary and artistic works, which are original intellectual creations in the literary and artistic domain, protected from the moment of their creation. So when is copyright protected? As defined a while ago, it is protected from the moment of its creation, irrespective of their mode or form of expression, as well as their content, quality, and purpose. A person must be the original creator of the work to be entitled of a copyright. He must have created it by his own skill, labor, and judgment, without directly copying or imitating the work of another. Evasively imitating the work of another. And so what are original works? We no need to memorize, just familiarize. Literary and artistic works. Periodicals, newspapers, lectures, sermons, addresses, dissertations, letters, dramatico-musical, musical compositions, drawing, painting, architecture, sculpture, engraving, illustrations, ornamental designs, maps, plans, sketches, drawings, photographic works, audiovisual works, pictorial illustrations, computer programs, other literary, scholarly, scientific, and artistic works. Another are derivative works. So derivative works are creations that are based on existing work. The law provides that the following derivative works shall also be protected by copyright: dramatizations, translations, adaptations, abridgments, arrangements, and other alterations of literary and artistic works. And of course, collections of literary, scholarly, artistic, or compilations of data and other materials which are original by reason of the selection or coordination or arrangement of their contents. So what are works not protected by copyright? So unprotected subject matter, those idea, procedure, system, concept, principle, discovery, or a mere data as such, even if they are expressed, explained, illustrated, or embodied in a work. News of the day and other miscellaneous facts having character of a mere items of press information, any official text of legislative, administrative, or legal nature, as well as any official translation thereof. Works of Government of the Philippines, the work created by an officer or employee of the Philippine government or any of its subdivisions or instrumentalities, including government-owned corporations, as part of his regularly prescribed official duties. So generally, no copyright shall subsist in any work of the government, except when the copyright is transferred by assignment or bequest in favor of the government. Author of speeches, lectures, sermons, addresses, dissertations shall have exclusive right of making a collection of his work, however, prior approval of the government agency or the office wherein the work is created, and created let's delete that, shall be necessary for the exploitation of such work for profit. Rights conferred by copyright. So copyright confers both economic and moral rights. So economic rights allow right owners economic rights allow owners to derive financial reward from the use of their works by others, and moral rights allow authors and creators to take certain actions. Again, moral rights allow authors and creators to take certain actions to preserve and protect their link with their work. Economic rights. So, copyright or economic rights shall consist of the exclusive right to carry out, authorize, or prevent the following acts: reproduction of the work or substantial portion of the work, dramatization, translation, adaptation, abridgment, arrangement, or other transformation of the work, the first public distribution of the original and each copy of the work by sale or other forms of transfer of ownership, rental of the original copy of the audiovisual or cinematographic work, a work embodied in a sound recording, a computer program, a compilation of data and other materials, or a musical work in graphic form, irrespective of the ownership of the original or the copy which the subject of the rental, public display of the original or other communication to the public of the work. Moral rights. The author of a work shall independently of the economic rights in Section 177 or the grant of an assignment or license with respect to such right have the right: 1. To require that the authorship of the work be attributed to him, in particular the right that his name, as far as practicable, be indicated in a prominent way on the copies and in connection with the public use of his work. 2. 2. To make any alterations of his work prior to or to withhold it from publication. 3. To object to any distortion, mutilation, or other modification of or other derogatory action in relation to his work which would be prejudicial to his honor or reputation, and to restrain the use of his name with respect to any work that is not his own creation or in a distorted version of his work. So in cases of original ownership of copyright, in cases of original literary or artistic works, copyright shall belong to the author of the work. In cases of works of joint ownership, the co-authors shall be the original owners of the copyright, and in the absence of agreement, their rights shall be governed by the rules of co-ownership. So the author or co-owners. If, however, a work of joint ownership consists of parts that can be used separately and the author of each part can be identified, the author of each part shall be the original owner, and the copyright in the part that he has created. Copyright ownership in the course of employment. So in case the work is created by an author during and in the course of his employment, the copyright shall belong to the employee if the creation of the object of copyright is not part of his regular duties, even if the employee uses the time, facilities, and materials of the employer. It is owned by the employer if the work is the result of the performance of his regularly assigned duties unless there is an agreement express or implied to the contrary. Okay. Limitations on the concept of copyright. So the recitation or performance of a work, once it has been lawfully made accessible to the public, if done privately and free of charge, or if made strictly for for a charitable or religious institutions or societies, will not be liable for copyright infringement. Second, the making of quotations from a published work if they are compatible with fair use. Third, the reproduction or communication to the public by mass media of articles on current political, social, economic, scientific, or religious topic, lectures, addresses, and other works of the same nature. Fourth, the reproduction and communication to the public of literary, scientific, or artistic works as part of reports of current events. Next, the inclusion of a work in a publication, broadcast, or other communication to the public, sound recording, or film, if such inclusion is made by way of illustration for teaching purposes and is compatible with fair use. The recording made in schools, universities, or educational institutions of a work included in broadcast, provided that such recording must be deleted within a reasonable period after they were first broadcast. The making of ephemeral recordings by a broadcasting organization, the use of a work by or under the direction or control of the government, by the National Library, or by educational, scientific, or professional institutions where such use is in the public interest and is compatible with fair use. And the public performance or the communication to the public of a work in a place where no admission fee is charged by a club or institution for charitable or educational purpose only, whose aim is not profit-making. Public display of the original or a copy of the work not made by means of a film, slide, television, image, or otherwise on screen, or by means of any other device or process, provided that either the work has been published or that the original or the copy displayed has been sold, given away, or otherwise transferred to another person by the author or his successor in title. Any use made And lastly, any use made of a work for the purpose of any judicial proceedings or for giving a professional advice by a legal practitioner. So the doctrine of fair use. The fair use of copyrighted work for criticism, comment, news reporting, teaching, including multiple copies for classroom use, scholarship, research, and similar purposes is not an infringement of copyright. The compilation, which is understood here to be the reproduction of the code and the translation of the forms of the computer programs to achieve an interoperability of an independently created computer program with other programs, may also constitute fair use. Factors to consider in determining fair use. First, the purpose and the character of the use, including whether such use is of a commercial nature or for non-profit educational purposes. Second, the nature of the copyrighted work. Third, the amount and substantiality of the portion used in relation to the copyrighted work as a whole, and the effect of the use upon the potential market for or value of the copyrighted work. So, copyright infringement. Copyright infringement is a trespass on a private domain owned and occupied by the owner of the copyright, and therefore protected by law. And infringement of copyright or piracy, which is synonymous terms in this connection, consists in the doing by any person without the consent of the owner of the copyright of anything the sole right to do which is conferred by statute on the owner of the copyright. A person infringes a right protected under this act when one directly commits an infringement. He benefits from the infringing activity of another person who commits an infringement if the person benefiting has been given notice of the infringing activity and has the right and ability to control the activities of the other person. Or if he has knowledge of infringing activity, induces, causes, or materially contributes to the infringing conduct of another. Okay. Plagiarism is different from copyright infringement because in plagiarism, it is a practice of claiming or implying original authorship or of incorporating material from someone else's written or creative work in whole or in part into one's own without adequate acknowledgement.